To conform with MCLE rules from New York's Continuing Legal Education Board, a 3-digit control number has been inserted into each topic or segment of this program. The control numbers must be written on your attestation form to receive continuing legal education credit for this program. This recorded presentation and the accompanying course materials are copyrighted by the New York State Bar Association and may not be reproduced without written permission. This is topic number 12 of the program, Bridging the Gap, Spring 2015. The topic is titled, Representing a Startup Business, Ethical Considerations for New York Lawyers. The speaker is Clifford Enneco.
Our last topic of the day is representing a startup business and ethical considerations for New York lawyers. Joining us this afternoon, we are very pleased to have Cliff Enneco. Cliff Enneco is widely considered to be America's leading expert on legal and tax problems facing entrepreneurs and privately owned businesses. He is best known for being the former host of a reality TV show called Money Hunt. He's the author of several books on entrepreneurship and small business management. He is a frequent speaker at our CLE programs. He chairs our Starting a Practice CLE program, which is offered every May. And he also is a frequent closer for our Bridging the Gap program. So you're in for a real treat. Please welcome Cliff Enneco.
Thank you. Thanks, kid. That's my speaker. All right, ladies and gentlemen, the one and only Kathy Suhusky, she without whom none of this happens, please. Absolutely. So, all right, your butts have been in these chairs for 2 solid days. You just got one more thing you got to suffer through before you can get the hell out of here. You're at the last level of this video game, and there's only one more troll that you have to defeat before you get the bag of gold or rescue the princess or prince. I don't know what happens in video games. Whatever the hell the reward is, the payoff. You only got one more thing you got to do here. Please don't get personal, sir. Yes, I do know that there is something of a physical resemblance. But let's just get this out of the way. The last time you saw anything this big and this purple, it was Barney. All right? Don't get personal about that. Trolls, ogres, if you can find another analogy, please do that. You're lawyers, damn it. Be respectable. All right. Now, I am so off my meds. Anyway, if you're looking at the bios of who we all are, and if you care a rat's ass about who any of us are up here at these last couple of days, one question that you're probably asking yourself right now is, what the hell is a guy from Connecticut doing speaking on a New York State Bar Association, program? Well, there's a couple of reasons. I mean, one is that I am a New York attorney, from the last 35 years, actually. I've been, back then we spoke Dutch, okay. But no, seriously, I am, I need these credits as much as you do. But also, too, I think what the Bar Association wants to do, they want to give you a little bit of a different exposure. Most of the people who've been speaking here the last couple of days are either with big law firms or smaller but very well established law firms. I am completely different. I am at the opposite end of the spectrum. You are looking right now at the law offices of Clifford R. Enneco. There are no thank you. There are no associates. There are no associates. There are no paralegals. There's no admin people. There's no dog or cat. It is simply me. Most of the time, I am practicing out of my home. Most of the time, I am naked. Except for my bunny slippers. Watch out, pal. They always sit in the front, these people. Okay. No, seriously, I mean, I joke about this. I tease sometimes that I have the first clothing optional law practice in New England, right? I talk about that, and I'm looking for associates. Funny thing, I've been making that joke now for 5 years. I have not gotten a single damn resume from anybody at this program. I'm doing something wrong with my marketing. I just don't know what it is. Anyway, but seriously, when you practice naked like this, though, ethics is not just a topic that is of academic interest. I mean, don't get me wrong. Ethics is very, very important. No question about it. But if you work in an established law firm or a larger law firm, it's not really something that's going to occupy a lot of your day. And it's not because it's not important, but because most firms have ways of dealing with ethical issues. So if you're working on a case or a problem and you get an ethical question, you don't have to really deal with that yourself. There's somebody you go to. In a big firm, it would be chairman of the ethics committee or something like that. You'd go and you explain the situation. They would say, okay, thank you. We'll look into this. Thank you. Pat, pat, pat. Now, please go back to billing hours. What you don't know, of course, is that the minute you leave that room, you have just gotten off the partner track. You don't know that. He's going to call the head of the managing partner and say, this guy, Enico, he asks too many questions. Be very careful when you raise ethical issues in the context of a larger firm. You may think I'm joking about that, but I am not. But when you practice naked like I do, ethics is something you encounter literally every day. You do. Practicing law the way I do is being in the middle of a law school ethics exam hypothetical virtually every day. All the things I'm going to be talking about the next 45 minutes or so are things that I personally have encountered in my practice within the last 6 to 9 months. And it really is like this. Okay, so let's begin. I'm going to take a slightly different approach. Let us cross this final bridge. Let us bridge the gap. Okay? Let's talk about business lawyers for a second. Now, I work mostly with entrepreneurs and smaller companies. Okay? What do business lawyers do? Well, first of all, I do not do any litigation or courtroom work of any kind. In fact, I will share with you that I've only seen the inside of a courtroom on 2 occasions. Number 1, when I was sworn into the New York Bar, 2nd Department in Brooklyn, and the second when I was sworn into Connecticut. I have no idea what an inside of a courtroom looks like other than that. My job is to keep my clients out of court. Small businesses, if they get sued, they die. And when one of my clients gets sued, an angel dies. That is the way I look at things. My job is to prevent that from happening, to deny the litigators of New York and Connecticut a living. That is my job, is to keep them out of it. Here's what I spend most of my professional time doing. I form business entities, corporations, LLCs, no surprise there, giving legal advice, and sometimes I get paid for it. That's really not so much of a joke. Seriously, if you really want to have a fight with a client, send them a bill, telephone conversation, 20 minutes. I guarantee you always get pushback on that. Cliff, wait a minute. We were on the phone for 20 minutes. Man, we were on the phone for like 15 or something like that. You're gouging me, man. No, really. It was 20 minutes. I got a stopwatch. I do timesheets just like I did when I worked on Wall Street many years ago. I always end up writing off time. Be careful how much you bill for telephone conversations. Clients get irritated about that. Drafting and negotiating contracts. There's the meat and soup of my practice, boy. When I send a bill out, drafting contract, 4.5 hours, I never get pushback. In fact, very often I get paid early. Very interesting. That's a disgusting job. Nobody likes to do it. And let me tell you something about this, folks. People, and I don't care what profession you're in, it's not just true of lawyers, it's true of any profession. People do not pay you for doing things that are fun and exciting and thrilling. The reason you get paid is because you take off of people's shoulders some of the ugliest, dirtiest things in life that they just don't want to do themselves. Anybody here think that drafting contracts is fun? Nobody, thank goodness. I know you're all kind of newbies, but you're absolutely right about that. Drafting contracts is not fun. It is tedious, it is boring as hell, and it's scary as hell. If I make a mistake in just one little clause of a contract, I could be sued for malpractice. So it is kind of a scary thing. People pay me lots of money to take that burden off of their shoulders. And that's what you ultimately get paid for. I draft and negotiate deals, transactions for my clients. I communicate with government agencies and regulators. I bill my clients. My favorite activity, don't forget to bill early, bill often. We'll talk about that in a minute. And then marketing the heck out of my practice. And we're going to talk a little bit about marketing in a minute, but I just want to make this point at the very beginning. We talk a lot about marketing and advertising, and of course when we talk about the ethical rules, we're talking about a million things that you can't do when you advertise. But let me tell you something. I've been working with small businesses and entrepreneurs for 35 years of my life. If you put a gun to my head and say, Cliff, what is the key to success in any small business, right? My answer is going to be marketing. If you know how to market yourself, what you do, the value that you add to people, you stand a very good chance of surviving practicing naked in any small business that I'm aware of. Do it poorly, and you will fail. Marketing is essential to success as an attorney in the 21st century. Do it ethically, do it professionally, but damn it, do it. If you are not spending at least, how many people here are going solo? How many naked people do I have in the room here? People practicing naked, about a third of the room. Okay, if you are not spending at least 25% of your total time on marketing-related activities, you are not giving that activity the attention it deserves. That phone does not ring, people, in my spare bedroom unless I make it ring. Okay? Do it professionally, do it ethically, but do it. Okay. So now let's go down each of these activities. Let's talk about some of the ethical issues that come up with all of these. Okay, forming business entities. Mo, Larry, and Curly come into my office, and they want to form an LLC. By the way, I have to drop a footnote here. Many of you are not aware there is a federal statute. Those of you especially who are going to do public speaking as part of your marketing program, there is a federal law, believe it or not. It's way in the back of the U.S. Code. It's in the back of, what is it, 50 USC Appendix or something like that. Whenever you are doing a talk and you're talking about 2 or more people forming a small business, you must use the Three Stooges. Okay? It is a must. It is absolutely, it's a requirement statute. There are regulations. You can use Shemp, if you wish, in lieu of Curly, if you were a fan of his. But my advice would be don't use either Joe Besser or Joe DeRita, not because it violates the statute, but because nobody remembers who the hell they were. So just don't do that. Mo, Larry, and Curly come into my office. They want to be, they're going to be forming an LLC, and of course, the question now becomes, who is my client? Who is my client at this point? Well, you know the answer. You go to Model Rule 1.13a. It says very clearly there that the LLC is my client, the corporation. Mo's not my client, Larry's not my client, Curly's not my client. It's the LLC. Sounds logical, sounds practical, but just try to get a start at LLC to pay your bill. Okay? You know, the trouble that you're going to have is that these 3 guys all think that you are their attorney. And they're the ones who are going to be paying you. In fact, I sometimes have situations where each one of them will write me a check for 1/3 of my fee. I tend to form LLCs. I tend to use a flat fee when I form LLCs. Okay? So, you know, I mean, this is a conversation that's very hard to have with these 3 people, that all of whom think of you as their client. In your materials, by the way, I do have a lot of materials, by the way, that I've given you. And unlike most of the speakers in this program, I've actually given you something that's actually worth using. Okay? I hope you don't mind. I actually gave you some forms that I use, of retainer letters and things like that. And one of the forms I have in there is a letter that I use at an initial meeting, an intake meeting with Mo, Larry, and Curly. And I try to make each of them sign it. Sometimes I do it by email. But simply acknowledging that while I'm going to do the best I can to represent this company, I'm not looking out for any of their individual interests. It's a good idea to get them to acknowledge that. Up front. Try to do it in a way that doesn't create friction with the client at the very beginning, but it's a very good thing to do because technically and ethically, the individuals are not your client, the LLC is. Okay? Second situation, you've been representing our business for years, Cliff, but I've got this little thing on the side that I need your help with. Model Rule 113D. You can represent the individuals involved in the LLC, even if you were the attorney who formed the LLC, Mo, Larry, or Curly, whoever it is that's approaching you, as long as that, of course, that you're not disclosing any confidential information of the client. Of course, as an owner of a small business LLC, he would know that anyway. But also to the fact that you are not engaging in any kind of a conflict of interest with the LLC. Now, here's where this comes into practice. How many of you form LLCs? Okay. When you do the operating agreement, how many of you put a non-compete clause in your operating agreements? Ooh, very few hands. Shame on you. A good operating agreement for a multi-member LLC should always have some kind of a non-compete clause that says something like, nothing in this agreement shall prohibit any of the individual members from doing outside activities, provided that they cannot, as long as they are members of the LLC, engage in any activity that directly or indirectly competes with the business or affairs of the LLC. You can tell how often I draft this language. I have it virtually printed on my brain here. Now, if your LLC operating agreement has a clause like that, and Mo comes to you and says he wants to do something on the side, what's a question you really should be asking Mo? Well, is this activity kind of related to what you're doing in the LLC? Or is it something wholly different? Are you and your son going to form a stamp collection business, going around to stamp and coin shows around the country, or something like that? You have to ask these kinds of questions. And if there's any doubt at all, my advice to the client would be, well, look, here's what I think we should do. Let's have a little conference call. Let's talk to Larry and Curly, and if they say everything's okay, then I think I can proceed with you on that, on this thing. In other words, let the 3 partners determine whether this is a directly or indirectly competing activity. And by the way, you should always have some kind of a non-compete clause in all of your operating agreements for 2 or more people. Would you consider a barter deal or perhaps debt or equity in our company? Yes. You can take chickens in payment. In fact, sometimes you have to. In this environment, trust me, when you represent with small businesses, kid, you get very creative when it comes to collections activities. I cannot tell you what people have offered me in return for the work that I do in polite company. But believe it or not, Model Rule 1.5, this is the section of the rules that deals with lawyer compensation. You can take property in lieu. The only thing you have to watch out for here, it's a tax rule that you have to watch out for here. Whenever you take property or non-cash compensation for the legal work that you do, you kind of have to do a little bit of an analysis and make sure that what you're getting is reasonably equivalent in value to the services that you perform. So, for example, let's say I form an LLC for you. A New York LLC, my flat fee for that is $1,000 plus the publication fee, whatever it is, depending on what county you're in. And let's say that you're a construction contractor and you offer to put a whole new 40-year roof on my house in exchange for these services that I'm performing. Do you see the gross disparity in value here? I mean, I don't know how much a new roof costs these days, but I got to believe it's at least $10,000, $15,000, $20,000. And I'm only providing $1,000 and plus in services over here. In a situation like that, I may have to report the difference in income as ordinary income on my tax return. The IRS rules on barter are in the Internal Revenue Code, and you should become familiar with them if you're taking non-cash consideration of any kind as compensation for your services. Debtor equity, the Rule 1.5 is very specific about that. It says that you can accept stock in a company, except I tell other lawyers not to do it, quite frankly. It creates an essential conflict between you and your client. If I am a shareholder of my client and they're getting ready to do a deal that has problems in it, and that's a deal that's going to be very difficult to do and may not have to be done, I've got a problem. Because on the one hand, as the company lawyer, I'm worried about them entering into that deal. But if the deal is successful, the company's going to be wildly successful. Let's say, for example, they're dealing with a bunch of crooked venture capitalists or something like that. And if they get that investment, they'll be able to launch their product and hopefully become the next Twitter or the next Facebook. As a shareholder of the company, I want them to do the deal. As a lawyer, though, I have reservations. Do you see the built-in conflict? My advice to young lawyers is always, if a client offers you stock in the company, the correct answer, I think, although it's not the ethically correct answer, but it's the best answer, best practices, is to say, yes, I would love to accept stock in your company, but then I can no longer be your lawyer. You're going to have to find somebody else to be your lawyer, because I don't really think that as a shareholder of the company, I would be able to act objectively on your behalf. I don't do it, and I'm a poor man today because of it. I still do CLE because I have never accepted stock or options in any of my clients. That shows you how ethical or stupid I am. I guess one of the two. I don't know. Okay, last but not least on this one, we're setting up a subsidiary in Idaho. Can you help us with that? Believe it or not, this is a very tricky one under the rules of ethics. Look at this. Model Rule 5.5. That's the rule that deals with multi-jurisdictional practice. Take a look at it. Look at it online at the New York State Bar website. It's only that long. It's only like 2 sentences long. And all it says is, you can practice in other states as long as you are not violating that state statute regarding the practice of law. Pretty easy, right? Let me tell you something. You can do a hell of a lot in other states. Very few states, hardly any that I've encountered, have a detailed list of what constitutes the practice of law. There's usually a teeny tiny little statute, it's about a paragraph long, that says that unless you're admitted to the bar, you cannot represent clients other than yourself in court, period. Well, no problem there. But what about the work that I do? Drafting contracts, representing clients before regulatory agencies. Is that the practice of law? Very interesting. Just before I came down here, I printed out New York statute, just as an example. For those of you who are interested, it's section 484 of the judiciary law. 484? Okay. Here's what New York considers the practice of law. No natural person shall ask or receive directly compensation for appearing for a person other than himself as attorney in any court or before any magistrate. Okay? I'm not doing that. I told you, beginning, don't do litigation. Or for preparing deeds, mortgages, assignments, discharge, leases, or any other instruments affecting real estate. Man, I do real estate. I'm not a dirt lawyer. represent businesses. I don't do shopping centers and crap like that. All right, I don't do that either. Or for preparing wills, codicils, or any other instrument affecting the disposition of property after death or decedent's estates. I don't do that either. I'm not a trusted estates lawyer. I don't do any of that. Or pleadings of any kind in any action brought before any court of record. I don't do pleadings. I don't do any of this crap. I'm not a lawyer. I don't do any of this. Kathy, I finally learned something in New York State Bar, CLE. I am not, this is it. What the hell am I doing here? I don't need these credits. Okay, go home. Okay, no, I'm only kidding. I got more time to do here, okay? But seriously, most states are very flexible. There's a lot of stuff that you can do. I think the answer to this question is, I haven't looked at Idaho's rules, okay? You'd have to take a look at it. But I'm pretty sure that unless Idaho has a specific thing saying that setting up LLCs and corporations is the practice of law here in Idaho, you could, ethically, under the rules, form that LLC in Idaho. Although I might suggest even then that you not do it. And the reason here has nothing to do with ethics. It has to do with malpractice. If you look at your malpractice policy, buried deep into that fine print, there's a little clause in there that says, and most states, by the way, have this as a rule of law as well, that if you're practicing law in another state, and under that state's law, you are held to the same level of knowledge and accountability as a lawyer who is admitted to practice in that state. So if you do this company in Idaho and you screw it up, you will be held to the same level of accountability for malpractice purposes as an Idaho lawyer would be. And I have no idea what kind of traps for the unwary Idaho has in their corporation or LLC statutes. But we've all got them. We've all got them. Every state has little gotchas in their corporation and LLC statutes that are designed with one purpose in mind: to trap out-of-state attorneys who dare to compete with the local bar. Okay? I mean, some of you know, in New York, for an LLC, it's our wonderful publication requirement, Section 203, the thing you got to publish the 2 notices. If you're not a New York State attorney, you have no idea. We're one of only 2 states in the entire country, Colorado being the other, that has a publication requirement, believe it or not. So that's a real trap for the unwary there. In corporations, for example, Section 630 of the BCL, that wonderful statute dealing with dating from the Depression, that says that if a business corporation dissolves and owes wages or benefits to its employees, the employees can sue the 5 biggest shareholders of the company in their personal capacity for the unpaid wages and benefits. You know that statute exists? In section, it's been around since the 1930s. It's like a little holdover from the Depression. But that's a real, I get calls from out-of-state attorneys who ask me to help them dissolve New York corporations because of that Section 630. That's our little gotcha. And every state has them. If you're going to do a corporation or an LLC in another state, print out the corporation statute, get a fine VSOP brandy or other liquor of choice, and read every damn word of the statute. Okay. Not saying not to do it, but just be careful. Okay, now, advising clients. Now, this isn't really legal advice, but believe it or not, the rules are actually very flexible here. The rules say that you can give advice other than legal advice. Certainly, I've been practicing law for 35 years. Okay, and I've been representing small business. I've represented somewhere around 15,000 small businesses in that time. Okay, when clients look to me for advice, they're not just asking, what does the statute say? They're saying, Cliff, you've been doing this for 35 years. What do people in my situation do? They want to tap into my database of experience here. You know, Cliff, I want to do the right thing, but really, what should I do? That's not just a legal answer. That's a legal answer. That's a business answer. I mean, after 35 years, I think I'm fairly competent of doing that. And that's why you hire an attorney who's been doing this as long as I have. You want somebody who has a wealth of experience in this field. And Ronald Rule 2.1 says you can do that as long as you clearly state, this is not strictly speaking legal advice, but, yada, yada. You can do it. If you are a CPA, you can do tax returns for the client as well. Okay, I personally don't do those. I don't really consider myself a tax lawyer, but I don't do that. Although if you put a gun to my head, I probably could. I actually do one tax return. I form a lot of nonprofit organizations. So I do the 501c3 applications, the 1023s and 1024s. I do all those. And I have a PTIN with the IRS because of that. Good thing to do, by the way. Even if you're not planning to do any other tax-related work, everybody and his brother is trying to form a nonprofit right now. It's just unbelievable. We are becoming a good nation. Great opportunities for lawyers. Okay. I've never really done this before, but a lot of clients are asking for it. Okay, this goes to the whole question of your competence and your marketing strategy too. You know, what happens when everybody is asking you for a certain service and it's something that you haven't done before? You know, you've been referring it to other attorneys, but all of a sudden so many people are asking for it, you start to wonder, you know, am I giving away too much money here? Am I leaving too much money on the table? Is this something that I should know? One thing that I'm actually kind of wrestling with right now is trademark filings. Historically, I have done trademark filings for my clients, basic ones. You know, as long as there's no, you know, I do a basic trademark search, and if I don't see anything that's even remotely close to it, I might decide to do the trademark filing for the client myself. But as I get older, increasingly, I'm not doing that for my clients because the rules are getting a lot more complicated. If there's even the slightest possibility that there could be an infringing mark out there, and I'm telling the client that everything's okay, that's going to cause me some sleepless nights, isn't it? So be careful what you take on. But when everybody is asking for a service, at some point you have to ask yourself, maybe I should learn how to do this, and maybe this is the client that I should be learning on. So just be careful. This is really more of a malpractice question. The rules of ethics say that you can, you certainly are not limited to the things that you've already done in your practice. You could certainly take on something new and learn as you're doing it. But be very careful, obviously, for malpractice purposes. You know, when you fill out your application for malpractice insurance, they ask you to pull out that chart as to the percentages, the percentage chart. You know, how much of your practice consists of each of the... Mine, you do not want to be my malpractice insurer. You really do not. Even though I haven't been sued in 35 years, you still don't, because what I do is, in every area except for litigation, I put down like 2% or something like that. And there's two reasons I do that. One is legitimate, because as a small business lawyer, I'm really kind of a generalist. I do a lot of things from soup to nuts. I really do. I do a little employment law, a little IP law, a little copyright law. It's one of the reasons why you do this kind of work, quite frankly. You're not just locked into one area of specialty. But the other reason is that if I ever were to get sued because of something, I don't want my malpractice insurer coming back and saying, well, wait a minute, you didn't check that box. You're practicing outside your areas of expertise. You know, I don't want that. So when in doubt, I put even like 1% in the box. And I'm not saying that that's the way what you should do, but that's what I do, okay? Put a little something there, so make sure you're covered by your malpractice policy. Same, by the way, for practicing in other states. There's a reason why, when you do your malpractice insurance application, they ask you, what states do you practice in? Why are they asking that question? You know, just general statistical information? No, it's because they want to deny you coverage if you're doing something that's outside those parameters. So whenever you fill out your malpractice insurance, go as broad as possible, and leave them as little wiggle room to get out of insuring you as possible if, God forbid, the you-know-what hits the fan. The law says X, but nobody really enforces it, so don't worry about it. Okay, this is one of the hardest things you'll have. And you will face this. If you're out there representing small businesses, sooner or later you will hit this one. There are a lot of laws that are not being aggressively enforced in the state of New York. They're on the books. They're there. You cannot just shovel them under the rug. But you also, but they are also not enforced very aggressively. Here's a classic one. Let's say a client comes in and says, Cliff, I've had a corporation here in New York now for the last 10 years. My wife and I are moving down to North Carolina. We've had it with the cold winters. We want to dissolve the company, but quite frankly, we don't want to go through all the hassle of filing the paperwork and doing whatever. What we just want to do is we'll file final tax returns. We have been paying taxes to the state of New York, and we're just going to let this corporation wither on the vine. Let the state come and dissolve us after a while. We don't want to go through all the hassle of filing articles of dissolution. Now, if you read Article 10 of the BCL, the Business Corporation Law, it doesn't give you that option. It says you must go through the voluntary dissolution process. It's not optional. You have to file the articles of dissolution, get the consent of the New York State Tax Department, which means you're going to have to file a final stub return for the first 3 years of 2015. They soak you for every last penny of tax revenue. When they see a taxpayer leaving the state, an angel dies, and they want to make sure that they get every last penny of revenue before these people head south, okay? Yet I will tell you something. Thousands of corporations leave the state every year, and they never go through the voluntary dissolution process. Okay? Here's a case where you have a disconnect between the law and reality. What do? Well, the one thing you should not do is say, don't worry about it. The proper way to advise a client into the situation would be to say, well, look, the statute requires that you go through the voluntary dissolution procedure. However, I would not be doing my job if I didn't tell you that a lot of people choose as a matter of policy or cost not to go through this procedure. The only thing I would caution you about is that if you do this, and if you ever want to come back into the state of New York again and start a similar business, this is something that may hold you up down the road. They may come after you for back taxes or something if they think that you fled the state. So if it were me, the better practice would be, let's do the voluntary dissolution procedure, let's do the paperwork the right way, you'll sleep better at nights. That's how I would advise the client. If they choose not to do it anyway, I can say that I've done my job. By the way, this is one of the areas where email is really great, by the way. I'm not a big fan of email. Like most lawyers, I have concerns about the perils of the reply to all and all that stuff. I mean, you've heard about that already. I'm not going to repeat that. But this is one thing. Whenever you have to document to a client that you had that conversation with them, email is great for that. Just make sure whenever you do an email that is on which your practice is relying, always print it out and put it in a paper folder. Yes, I know it's 2015. I know about that dead trees are going the way of the dodo bird. I know that. But I'm going to tell you something about how many of you here use Gmail for your email service? Okay. A lot of people. I do too. Okay. Have you ever backed up Gmails onto a CD? Try it sometimes. Now, I'm serious. I mean, I know they give you a lot of storage and stuff like that. Most people don't do it. You just keep it in the cloud. I always like to back things up. There are Gmail backup utilities. They're free. There's about four or five of them out there where you can actually back up all of your emails. Right? Pretty good, huh? In fact, I'll even tell you one. There's one called gmail-backup.com. That's the one I use. Gmail-backup.com. It's not a Google product. It's an independent thing, but it's a free download. They sell you some advertising. You look at a couple of advertisements, and it's a free download. Works beautifully. Backs up all my emails, except for two problems. It doesn't organize the emails into categories, and it doesn't preserve your headers. So after I back up all the emails onto my CD and I go to look at them, the first one says January 15, 2015, 08.15.37. The second one says January 15, 25, 08.15.38. You have to, if I have to find a specific email on that CD, I got to go through every freaking one of those emails to find the smoking gun saying that the client agreed to this thing. Whenever you do an email that is sensitive, print it out, put it in the client's paper folder. Yes, you will keep a couple of office supply companies in business by doing this, but you will also be able to sleep better at nights knowing you will always be able to lay your hand on that email. I had a situation a couple of years ago, about 8 or 9 years ago, a client asked me to form an S corporation in New York. Now, of course, you know when you do an S corporation in New York, you have to file two documents, one with the IRS and one with the New York State Tax Department, right? The CT6, right? Well, this client's accountant didn't want me to do those filings. Didn't want me to do those filings at all. He wanted to do that himself. He had a relationship with the client for 20 years. I think he felt I was a threat to this as to his relationship. Stupid, of course. I don't do I'm not an accountant. But so he said that he wanted to do it. I said, fine. Do me a favor. Normally, I do those two filings as part of my S Corp service. Could you please just send me an email with a CC to the client telling me that you're going to handle those two tasks? And he did. And I printed out that email and I put it in my folder. And I am so glad I did. Because last year, I got a frantic call from the client. Apparently, the accountant forgot to file the 2553 with the IRS. The client was audited. They found out that he didn't do the S filing, so now they're going back and treating the company as a C Corp for the last 8 to 9 years with a massive tax liability. The client called the accountant, and what did the accountant said? Well, that was your attorney, that guy up in Connecticut. He was supposed to do that, right? But I have the smoking gun email saying he was going to do that. I took it, I scanned it, I emailed it to the client. I have not heard a word from that situation since. Okay? That can save your life. Seriously. Do business via email if you must, but whenever you're in a situation where you have a smoking gun email that may go to your reputation as an attorney, print it out, put it in a place where you'll always be able to get hold of it quickly. Don't count on the fact that you're going to be able to get it from Gmail or the cloud at that point. Okay? All right. I can't help you, but my good friend Joe can. You can certainly refer clients to other attorneys. I do this all the time. Whenever I get a call from somebody who I think is a flaming idiot, I always make it a point to refer them to somebody else in my local bar association that I can't stand. I hope that doesn't shock anybody. But that's exactly how you deal with that situation, by the way. The client who is the utter jerk from hell, right? That's how you deal with it. I'm thinking about hiring you, but could you answer a couple of quick questions for me first? Okay. There's an ethical dimension to this, and there's a real dimension to this. Okay, Model Rule 118 deals with your obligation to a prospective client. Okay, here's a situation where the person hasn't hired me yet, but they kind of want to test the waters a little bit and ask me a couple of questions before they do anything. All right, to an extent I will do that, but only to a limited extent. The thing you got to remember, the ethical thing you got to remember is that you have just the same duty to that prospective client that you do to somebody who's paid you. And let me just share this with you. There's only one thing worse as a lawyer than being sued for malpractice. Being sued for malpractice is probably the worst thing, or an ethical violation. That's the worst thing that can happen to you, with one exception. There's one thing actually that's worse than that. And that is being sued for malpractice because of advice that you gave away for nothing. Or at least you didn't get something for it. If that ever happens to you, you will feel as dumb as the people in those social media cases in the last presentation. Trust me, you will be absolutely that. You know, be very careful how much free advice you give away, not just because it's not, for business reasons, obviously, but also because of the ethical consequences. You will be held accountable for that free advice just the same as you would anybody else. That's the ethical dimension. But there's also a very practical aspect of this, too. How many of you heard of the word showrooming? How many people here know what that word means? Showrooming. It's a word you should look up on UrbanDictionary.com. Here's what, showrooming, and some of you have actually done it. Okay, that's where you go to a brick and mortar store. You get the salesperson. You talk. You get him to talk about all the new smartphones that are coming out now with Samsung, and he tells you all the differences between the 5 of them. You talk to him. You spend an hour in there. You pick his brain. You pick exactly the one that you know is right for you, and then you go home and go on Amazon and buy it online for 30% off. That's called showrooming, and it's killing brick and mortar retail in a lot of big ways. Let me tell you though. As a lawyer practicing naked, you will be showroomed by prospective clients. Here's how I can always tell I'm being showroomed. A client will call me and saying, Cliff, just out of curiosity, I've been looking online. I want to form an LLC. I really want to hire you to do it, but just, I'm looking at the form online, right now, and I just don't know question number 4 is kind of stymieing me. How should I answer question 4? I mean, what would you tell a client to do with question 4? That's when you kind of know they're filling that form out online, aren't they? Oh yeah, you know that. So what I have to say is that some people, and don't get me wrong, I might give them an answer to just one, but if it's 2 or 3 things, how about question now? Now let's look at box number 6. How would you handle that? These people are usually very, very obvious. If they're asking more than just 1 or 2 questions, forgive me, you ought to be getting paid for that. From a business point of view. Don't be afraid to say, well, you know what, just to let you know. I don't mind giving out some free information. I got a couple of, articles that I've written. I'll be happy to email them to you. But if you really want to get one-on-one here, I really got to charge you for that. Because it's going to take me some time to learn about you, what you're doing, and it's going to take time. It's not something I can do in a 3-minute introductory phone call, much as I would like to. Don't get me wrong, I'm not saying that you shouldn't cooperate with a client who has legitimate questions and go through the situation. You got to spend some time on the phone just understanding what kind of services the client needs. But be careful of showroomers, because there are a lot of them. Some of you don't. How many people have heard of the franchise We the People? Have you ever heard of this? It's a franchise. And there's actually one in Greenwich, Connecticut. I don't know about New York, but there's one right across the border in Greenwich. This is a legal services franchise. They don't practice law. They don't give advice. They think they can't do that, although I think in New York, under Section 44, they can. But don't tell them that. But seriously, what they do is they do document prep. That's basically what they do. So if you want to form an LLC and you don't want to hire an attorney, they'll do the LLC paperwork and they'll charge you like a third of what an attorney would charge. What they do not do is give you advice or answer questions. So if you're not sure about whether whether you want to be an LLC or a corporation, we the people will not help you with that. They'll give you some checklists or something like that, but they're going to tell you to talk to an attorney, right? That's where you're going to get showroomed. They're going to call you, ask you for advice about whether they should be an S-Corp or an LLC. That's always the most popular question, S-Corp versus LLC. And then when they get the answer, they're going to go to We the People and get it done for a third. Get a third of what you're going to charge. Seriously, be careful about this. Watch out for showroomers. Don't ever, and by the way, I know it's tempting, but because of Rule 118, do not give them the wrong answer. I know that's tempting. You know what? Let me play with this guy's head. He thinks he's so smart. Ha, ha, ha. Yeah, question 5. Yeah, say yes. Yeah, absolutely right. You agree that they can sue you and put a lien in your firstborn child. Yeah, sign that box. Yeah, put that box right there. Yeah, now don't resist that temptation because you still have your obligations under Rule 118. Okay. Drafting and negotiating contracts. I love this one. Okay, now let's talk about contract negotiation. I want you to protect my interests, but for heaven's sake, don't kill the deal. I really need this job. How many of you have had this kind of conversation with somebody? Yeah, it will. I have a word for this. Model Rule 1.2 I call the wimpy client rule in the model rules. You will find client. Now, of course, those of you who are a little older will remember, under the old Code of Professional Responsibility, you had a duty to represent your client zealously to the fullest extent permitted by law. Now, that rule has been softened a lot in the model rules, but that attitude is still kind of there. And, of course, if you're a litigator, that's exactly what you should be doing. But when you're in a situation where you're drafting a contract for somebody, there's always a tension between being too aggressive and being so aggressive that the client loses the deal and now doesn't want to pay you because he thinks it's your fault, because you blew the deal for him. There's always that tension. The correct way to deal with it is to say to the client, well, all right, here's the deal. I see 15 things in this contract that are wrong, and I think are going to be problematic. Let's go down the list. There are a couple here that I think we absolutely have to try to get clarified. Some of these other things you may not care about, but let's go through this list because I want you to know what you're not getting if we don't really tear this contract apart and try to get it right for you. Okay, and then when I've had that conversation with the client, what do? Email. Confirmation. Okay, this will confirm. We discussed the following matters. You gave me authorization to proceed on these 3. You said you could live with all those other 7 things. Print it out, put it in a folder. I'm serious. Wimpy clients have a nasty habit of forgetting what they agreed to when the you-know-what hits the fan down the road. They're going to say, their first thought is, Cliff, why didn't you tell me that could happen? That's when you got to produce the smoking gun email within 15 minutes and say, look, just to let you know, we did discuss that. You said you were okay with that. Okay, and as the client, I have to listen to what you want. You told me you really wanted to get this deal. So now you got to live with this. I'm sorry, but I didn't just forget to do this. Wimpy clients have a nasty tendency to turn evil when the bad stuff hits. Okay, just be careful about that. I'm not saying that the client is the enemy. Please don't come away with that. That really isn't the truth. But just remember, there's only one person in this entire world who can sue you for malpractice, and that's a client. Okay? The other attorney cannot sue you for malpractice. The government cannot sue you for malpractice if you screw up, unless, of course, you violate a statute or something like that or commit a criminal act. Okay? Only person who can sue you for malpractice is the clients. That's why you got to watch them. They're always a potential plaintiff. They're never the enemy, but they're a potential plaintiff. As anybody who's ever represented doctors know, even nice doctors sue for malpractice. Okay. Always be sure, whenever a client makes a concession in a negotiation, get confirmation via email. That's the lesson I want to beat into your head. Whenever a client says, yeah, you know what, Cliff, don't worry about that, I can live with that. Get it in writing from the client. Okay, this is discussed. I told you about this, you said it was okay. Okay, Cliff, print it out, put it in a folder. It might save your life. Here's when I get it. I do a lot of work with people who are buying franchises of various kinds. I'm buying a franchise. There's some stuff in the franchise agreement I don't like, but the franchise says it won't change anything. They don't negotiate their documents. What do I do about that? Anybody here ever deal with a franchise? You know they don't negotiate. If you ever deal with a bank, by the way, same thing. They will not negotiate their loan documents. They'll change typos and the numbers and stuff, but they don't negotiate anything at all. Landlords, too. Anybody here represent landlords? Seriously, you should. It's the easiest practice in the world, representing a landlord, because all you got to do is you have to know one word. No. Tenant asks for anything? No. We don't have to think about anything. Don't have to research or do anything. Just grab it. No. It's a tenant. You know, no. We don't give that. It's the easiest practice in the world. And you're getting paid for that, boy. It's a great life. Actually, I don't envy landlords' attorneys. I'll be very honest with you. Landlords' attorneys, I don't know how they do it. It's kind of like divorce lawyers. I mean, you've got to have a hide like a rhinoceros to represent commercial landlords. I just don't know how those people do it. If you do, God bless you. It's beyond my. It's something that I probably will never do. Okay, but seriously, here's what you have to do, though. You still have a duty to your client here. Here's how I deal with that situation. I say to the client, look. Right now, I mean, yes, you're right. Most franchises don't like to negotiate their documents. Sometimes it's all I can do to get them to correct mistakes that are in the document, drafting errors. Okay? But I view my role in this process as much as an educator, as a lawyer. If you're like most people, you've never had to read a 200-page set of documents before in your life. Okay? You're being asked to do that now. I guarantee you, if you try to do this yourself, after 5 or 10 pages, your eyes are going to cross. What I'm going to do, I'm going to go through these documents. I'm going to send you a list of 30, 40, maybe more things that you and I need to discuss, and then we're going to schedule a conference call to go through all of those points together. And if at the end of that conversation there are issues you feel you should discuss with the franchise, I will put together a second memo with just those points, and you can send that on to the franchise as, quote unquote, your attorney's comments. Okay? What are you doing here? Well, you're not really negotiating. What you're really doing is acting as your client's bad cop. What you're really saying is, here are all the things I think can come back and bite you if you go forward with this deal. And by putting your name on it, you're helping your client, because then he can go to the franchise and say, well, you know, I'm really okay with all this, but my attorney has a few questions, and frankly, some of them are pretty interesting. Can you spare some time? This clause, especially where you say you're going to take a lien on my firstborn child. You know, I'd like to ask a few questions. Seriously, if you've never represented franchise documents, don't laugh. There's a lot of crap in there. They're worse than bank documents. They really are. But you still have a duty to help your client, and that is how I do it. Also, too, I can justify a much higher fee for doing that, quite frankly, than just saying, no, don't do this deal. You know, seriously, bring the client to that point, okay, where they say, you know what, maybe this franchise isn't the greatest thing in the world. This, you know, frog legs on a stick. Maybe I shouldn't go into that concept. Maybe that's a concept that's not really ready for the 21st century. Oh, don't laugh. If you want to, seriously, if you want to have some fun, seriously, go to some of these, you know, there's some of these websites like franchise.com where they list, you know, all the franchises that are out there. Look at some of the crazy-ass franchises that are out there. I am serious. Some of these new things, they've only got, you know, one franchisee or something like that, and they're in Utah or something like that. And they're going to, this guy, your poor client's going to be the first person, not only in New York, but on the entire East Coast, who's going to be testing this concept. Trust me, you know, both hands are like on my malpractice policy, like this, when I get a call like that. You'd be amazed at some franchises that are out there. We the People, for one. I actually got a call about a month ago because I was thinking about buying a We the People franchise. I say, man, you got guts. You are calling an attorney for help in reviewing the documents that will help you buy my competition. Either you are one of the most courageous people I have ever met, or you are one goddamn stupid person. That's all I can tell you. Seriously, what can I say? Those are the moments you live for as a lawyer. Okay, we can skip on some of this other stuff. Okay, now let's talk about doing deals, okay? I understand you did a great job representing my good friend Joe. I want you to get me the same deal you got him. Now, first of all, I'm delighted that this happened. Why? Because I have a satisfied client. He loves me. He thinks I'm great. He's going around telling everybody that Cliff Enneco is the greatest lawyer in town, right? I like that. Okay? And this guy's coming to me now. He wants me to do the same thing for him that I did for the other person. By the way, I get this a lot in franchises, right? I represent the first franchisee well, and the next thing I know, the franchise is telling there are other people in Connecticut and New York, hey, there's this franchise attorney, Cliff Enneco, he's really great. Why? Because they now know my shtick. They know what I'm going to be coming back at them with, right? So they're actually giving my name out to clients. I got the other side doing my marketing for me. How often does that happen in your life? okay? But I got to be careful here, okay? Because it's not a conflict of interest situation, because in both cases I'm representing the franchisee. I'm not on opposite sides of the table, but I got to watch out here for confidentiality. In order for me to help this person, I got to tell him the deal that Joe got, which is disclosing confidential information. With this one, I got to do a very subtle dance with the client. I got to say, well, look, there's a rule of ethics that say I really cannot disclose to you what Joe's deal was. Here's the deal, though. If you hire me, I give him the same thing about being an educator. I'm going to go through the same questions that I did with Joe, and I do have a sense of how flexible the franchise will be on some of these issues, but I don't want to just do it exactly the same way, because quite frankly, you and Joe are entirely different people. Things that he cared about as a deal point are things that probably you don't even care about. Whereas things that he didn't care about are things that will be a deal breaker for you. And by the way, that is honest. That is an honest answer. No two clients are exactly the same that way. So I try to persuade the client, look, let me just do the same job that I did for Joe. Don't worry. If it's something I think that's important for you, and if I know the franchise will be flexible on it, be assured we will raise that issue in our discussions with the franchise. But I can't treat you the same way that I treat Joe. And most clients buy into that logic. See, a lot of the times what's happening here, why is the client doing this? The number 2 franchisee. Why is he calling me? Because I'm a great lawyer? Or because he thinks he's going to get a cheaper deal because he's the number 2 guy? See, there's that factor too. If I charged Joe $3,000 to buy into this franchise, and now this guy is coming and he wants to buy the exact same franchise in a different territory, how long is it going to take me to turn around that first memo? 5 minutes, right? And he thinks I'm only going to charge him for 5 minutes, right? First of all, if Joe ever found out, if I did that, and if Joe ever found out about it, he would have my head, quite frankly. How many of you think that that's fair? To charge the first guy $3,000 and the second guy $100? I wouldn't do it. But yet I also have to justify charging the second client $3,000. See, I told you, when you practice naked, you live with this crap. This is the stuff that you will encounter every day when you're in this kind of world. Okay, I'm not a confrontational person. Can you handle all the negotiations for me? I want you to negotiate the business deal as well as the legal stuff. Model Rule 5.7 says you absolutely can do that. 5.7 is the rule that says what you can do besides practicing law for your clients. So that's a good rule. Some of the rules you can kind of fudge a little bit. You don't really have to look too closely at some of them if they're not relevant to your practice. But there are some I think every attorney needs to look at, and this is one of them, 5.7, because clients will ask you on occasion to do things that go beyond what the purview of what a lawyer normally does. And the answer is 5.7 says that you can, but what I would suggest is document the hell out of it. If you are negotiating a purchase price of a company and you are not somebody who's familiar with valuation models, you are taking a hell of a risk here. Okay, so just be careful. I personally do not get involved in purchase price negotiations. I will do letters of intent for a client. I will show them, well, here are the things that people normally, the business terms that have to be negotiated, but I try to stay out of the actual negotiations unless it's a business that I am very, very familiar with. So, for example, within the last 3 years, I have helped 6 people buy liquor stores within a 10-mile radius of my home. I can get you a deal in Connecticut, trust me. So if you come in and you're number 7 who's going to buy a liquor store and you ask this to me, I might take that on a little bit because I just know exactly what liquor stores are going for in my area. I just happen to have that inside baseball in my head. But if it didn't rise to that level, I probably wouldn't take it on, to be honest with you. Even I have my limits as to what I will take on. And by the way, when you're representing liquor stores, don't ever take your fee in trade. It gives the profession a very bad name. This is why EAP exists, okay? Be very careful. We have a bad enough reputation as it is. Do not make it any worse, please. Okay. That's another example of the wimpy client rule. Okay, interfacing with government agencies. Okay, I just found out I was supposed to register my company with state X years ago. What do? If you do any kind of small business work, you will encounter this, and this will amaze you. A client will call you who has been doing business in New York for 15 years. They have, as a corporation or LLC, they have paid taxes to the state of New York all that time. They've done everything. They do not owe a penny to the state, but they have never registered with the Secretary of State's office. Read the penalties in the statute when that doesn't happen. They can charge, the state of New York can charge something like $2,000 to $3,000 a year for each year that the corporation was illegally not registered in the state of New York. If you tell the client that they have a $30,000 bill to file a one-page piece of paper with the Department of State, they are going to have a hissy fit. They're not going to like that. Now, of course, if you've ever dealt with this paperwork, it is very tempting, but it's a temptation I think you should resist, to file the application for authority or the certificate of incorporation, not the certificate of incorporation. This is mostly foreign corporations that have this issue. Delaware. Somebody told this guy 15 years ago that you can form a corporation in Delaware, and as long as you pay New York taxes, you don't have to register with New York. That is baloney. But a lot of people believe that, especially now they get the information off the internet. You know what I'm talking about, right? You've had this problem, it sounds like. Seriously, and it's hard because it's so tempting to file the application for authority and where it says, when did the corporation first start doing business, and putting in like today's date. But if you do that, you are knowingly filing a false document with a government agency. That is a Class D felony in New York. Look at the penal law. Okay? This is serious stuff. You must resist that temptation at all costs. When you are dealing with a government agency, you must abide by those agencies' rules, even if you think they're total baloney, even if they're regulations that you know are not being aggressively enforced. If it's a choice between making a client unhappy and possibly losing your license and going to jail, I think most of you know which way to go on that. In fact, I will share this with you. If you are ever unfortunate enough to be in a situation where you have a choice between malpractice liability and losing your license, take the malpractice liability risk. Do not take the risk of losing your license, because that could get on your record forever, and there's no way of getting out of that. You know, I may not be the brightest lawyer in the world, but damn it, I am ethical, and I pride myself very much on that reputation. And may you never ever be in that situation. Okay, I personally never have, but if it ever happens, you know, this is where you talk to your advisor. Okay, the form asks for my home address, but I don't want my home address to be made public. This is a problem with a lot of the New York State forms. A lot of the New York State forms require an actual physical address. They don't like P.O. boxes. Some states allow P.O. boxes, but New York doesn't. I'll give you one. Here's a piece of advice that's really solid here. UPS store private mailbox addresses. You know what UPS stores are? You get a box, but it's an actual street address. It's 123 Main Street, suite number 456. Seriously, the Department of State will accept those as street addresses on their forms. Suggest to your client that they get a UPS store address if they don't want their home address. And I also tell them to get a UPS store in a town other than where they live. Because if somebody is really trying to find them, all right, and they have the UPS store in Mayapack, okay, and they're listed in the phone book in Mayapack. I mean, most creditors and potential plaintiffs can probably put two and two together and find them anyway. Okay. All right. Let's do the next one here. Oops, there we go. Okay. Now let's do something to the thumbs up. Billing clients. Okay. The surest way to have an angry client in a solo law practice or small law practice is to send them a bill that they are not expecting. That is the surest way to have an angry client. That's the surest way to have a receivables problem. Sending a client a bill that they are not expecting. When I take on a client for the first time, I over-communicate what things are going to cost. Clients tell me, Cliff, shut up. I don't want to know that that's going to cost me an extra $25. No, I'm telling you anyway. Because I have learned over the years, clients are perfectly willing to pay a reasonable fee for legal services as long as there's no surprises, as long as they know what that bill is going to be. If you tell them something's going to be $500 and you send them a bill for $1,000, even though you can justify every penny of that $1,000 bill, you are going to have a fight on your hands with that client. Over-communicate. Again, another positive use of email. By the way, just to let you know, we had a little snag here. The name that you wanted wasn't available in the state. We're going to have to change it to a little bit, and there's just going to be a little extra fee for that, just to let you know. Okay, just get the job done. Great. Get it in writing. You're okay. That's how you deal with situations. I will tell you the truth. In the 35 years that I've been practicing naked, I have only had one or two receivables problems in all that time. I really manage this process very carefully. Lesson number 2 about billing. Big receivables almost always start out as little ones that get out of hand. If a client is really getting behind in payments, stop working. for them. Stop digging that hole and making it deeper. Okay? Obviously, if you're a litigator, there's some rules of court about withdrawal and stuff. You need to know the rules about withdrawing from a case. You can't always withdraw just because a client owes you money. But outside of the litigation realm, I will tell you, it's perfectly valid procedure. Tell them, well, all right, tell you what then. We have a little problem. I will tell you, I send my bills out. I always try to get as much money up front as I possibly can. The balance is due. I send them a monthly bill. The bills are net 30. On day 31, if I have not received payment, I send the client a very nice professional email with a copy of the invoice saying, by the way, my records indicate this invoice is still outstanding. If you have already paid this in the last couple of days, please disregard this message. Otherwise, please address this within the next 48 hours, or else I will have no alternative but to discontinue service until we resolve this. Payment almost always comes in within 2 days whenever I do that. People do forget. People do forget. The second thing is bill promptly and bill often. If you have a client that you're doing a big case or a big matter on and you have not billed them in 6 months, it is not their fault that they are not paying you. Okay? Especially those of you who bill by the hour. How does a client know how much to pay you if you're billing by the hour? You've got to tell them. And believe it or not, I know attorneys that will go 2, 3, 4, 5 months without sending a client an invoice. Look, this is part of the discipline of running your practice, okay? I don't care. Pick a day every month. For me, it's the last day of the calendar month. I don't care how busy I am. I do not care what other things are demanding my time. Unless I have a closing that day, which I sometimes do because it's the last day of the month, I turn the whole world off. I put the phone on mute, and I just sit down and I do my bills, and I get them out in the mail that day. It doesn't have to be the last day of the month. Make it the anniversary of your birthday, the 15th of the month. But just take one day and just do your bills and get them in the mail. Because if you send a bill out late, even though it says net 30, guess what? It's going to go to net 45. Because when a client gets if a client gets a bill on September the 25th that's due September the 30th, because it took you that long to get the thing in the mail, they're going to think and they're going to take another 30 days to pay you. They are just going to do that, and there's nothing you can do about it. If you get your bill out the first of the month and it arrives within a couple of days, most often you will get paid before the end of the month if you're billing that 30. Are you with me on this? Seriously, find the time, do your bills. I had a landscaper that used to do this, and I fired him for this reason. Good landscaper, did a marvelous job, right? But he never would send me a bill. Even though I call him up. Hey, listen, Joe, how much money do I owe you for this month? I don't want this to wait. Can I pay? No, I'll get a bill. I'll get a bill. Didn't happen. April, May, June, July. Finally, December 15th, a week before Christmas, I get a bill from him for $13,000 for the whole year. Don't get me wrong. He was a good landscaper. He deserved every penny of it, but it's a week before Christmas. And the bill is payable on receipt. Twisting the knife. Don't bill like that. Please don't bill like that. Bill promptly, bill often, and the minute you see a bill going late, stop, call the person up, try to work something out. Don't get me wrong, people get in over their heads. I'm not saying it's a bad situation, but big receivables almost always start out as little ones that get out of control. And unless you're subject to a court rule where you cannot stop working for the client, find a way to do that so that that problem doesn't grow and get out of control. Always do a narrative bill. A client should never have to ask for a narrative bill. It's something you should always give them. You know what a narrative bill? That's where you detail the time. On thus and such a day, 2.5 hours, here's what I did. Always make sure you do that. When clients do not pay bills that say for services rendered ... $5,000. Maybe there was a time when they used to, but trust me, they don't do it anymore. I always give a client a detailed bill. They don't ask for it. It also eliminates their ability to raise issues when they see exactly what I did. And also, too, it's a good device for me, too, because if I did spend too much time on something and I see that, I really shouldn't have spent 3 hours on that research, okay, I'll cut that back to 2. It gives you the chance to manage the process a little bit. It enables you to see things that really you shouldn't be billing for and that might cause problems with the client. You can catch it. Always do your bills yourself. I never trust my bookkeeper to do my bills for me. I always do my bills. Because I always do narrative bills for that reason. You want to do that. And of course, it is totally unethical. You cannot charge for discussing a bill. That's in Rule 1.5. That is black letter rule. You can never charge for discussing a bill. Tempting though that is. Okay, here we go. Oops. Okay. Now let's talk about marketing, and then we're basically done. Okay, hey, while working for another client, I just learned you can do X. Why don't you, I think this would be a great thing. There's this new law out there that says you can do things a little different way. Why don't you consider this? What's the ethical issue here? Are you soliciting the client? Okay, you all know there's a rule out there that says you can't chase ambulances, right? You cannot solicit legal work directly from a client. You can do that, but let's say that you do in the course of this seminar, you learn something and all of a sudden you think, hey, my client Joe could really benefit from this. You got to be careful how you do it. Because if you do it the wrong way, it's going to be considered a general solicitation under Rule 7.2, which you don't want to do. So what I would do in a situation like this is I would do do you guys do a newsletter to your clients frequently? Oh, you absolutely should. Nobody? Oh, you're raising your hands. Boy, you know nothing about marketing. Ooh, baby. It's perfectly ethical, perfectly fine. Of course, you have to put attorney advertising on it. There's a couple of rules as to what you say in there. But you can send a weekly or a monthly email. I get them from law firms all over the place. Sometimes this is how I learn about new statutes. It's because I get a lawyer in California sending me an email for a client email. You should. And then forwarding it to the one client saying, hey, Joe, take a look at my email this week and call me if you have some time. Okay? Doing it as a general solicitation to all of your clients makes it more likely that the person will respond. But just calling up the client out of the blue and saying, hey, by the way, I just learned there's this new trick. You can do something a brand new way. I think you ought to consider it. Make sure that you do it in such a way that it will clearly be seen as educating the client and not handling them for business. Okay? Here's one of the toughest ones on marketing. Can you please give me references? How many people here give references out? Good. Not too many of you. A couple of you do, but that's all right. Again, it's not prohibited by the rules of ethics, but you have to be very, very careful how you do it. Okay. Good. Be very careful how you do it, because if you ask me for a reference, and I decide I'm going to give you a reference to one of my clients, I have to disclose to you who the client is, don't I? All right? And let's say that it was a very touchy matter where there might have been some conversations that were attorney-client privileged. I personally don't like to give out references. I'll be very honest with you. Too many things can go wrong there. The rules of ethics say that you can do it as long as the client consents. So, of course, you can't pay the client anything. Be very careful about that. If you ask a client to give you a reference, and the client comes back and says, well, okay, will you give me a discount on my next bill? That is absolutely prohibited by the rules of ethics. You cannot, I shouldn't say that. It's not prohibited, but you have to disclose that to the person that is asking for the reference. The rules of ethics say that whenever you get a testimonial or endorsement for which you paid them something, you must disclose that compensation, that payment. By the way, that's also a Federal Trade Commission rule, too. That's not just a rule here. So let's say, for example, some blogger a legal blogger says that you're the greatest creditors' rights attorney in the whole New York City metropolitan area, and you send him a bouquet of flowers or something like that saying, thanks for that wonderful endorsement. Technically, you have paid something, you've given consideration for it, and that has to be disclosed publicly whenever you take consideration. That's an FTC rule as well as an ethical rule. I don't like to give references. Here's how I handle it. I will say something like, look, to be perfectly frank about it, I don't like giving out references for a number of reasons. There's a rule that says I cannot tell you who my clients are, and even though I can ask them for consent, I have to protect their interest and make sure that they don't say too much about what we worked on, because if they do that, then they have just blown the attorney-client privilege for what we discussed, which, by the way, is very true. The client can say anything in the world, but if they say too much about what you did for them, they could blow the attorney-client privilege for communications that you had. So my preference would be, forgive me, I don't like to give references out. If you look on my website, I have 35 years of experience. I have worked with 15,000 clients in that time. I have not been sued for malpractice once. Please, I'll be happy to explain to you anything more that you might want, but I would rather not give you exposure to my clients. And most people, and occasionally I do lose business because of that, because there are people that don't trust, people that don't give references, but it has never been an issue for me. 9 times out of 10, the person buys that logic and we go forward. And frankly, the other 10, the 10th guy is probably somebody I don't want as a client anyway, because they're fishing for something. I know a client who was getting divorced a couple of years ago who actually called every divorce lawyer in Stamford, Connecticut, and had an introductory 15-minute free conversation with he called about 12, 13 lawyers.
The MCLE verification code for this program segment is 374.
Because he didn't want his wife to get any of them, his spouse to get them as an attorney. He was trying to disqualify them. People play that game sometimes, so be careful. Your client newsletter, your website, there's rules about that. Speaking to local business groups, okay. Two things here, because obviously I do a lot of this. Believe it or not, this is required by the rules of ethics. It's in section 7.1, I think it's paragraph M or N. It's way at the end. It says that if you are giving a talk, you must make a statement at some point, which I am doing right now, is that while I am giving out legal information, I am not in a position where I can give any of you one-on-one advice. I have a disclaimer. When I speak to non-lawyers, I have a whole disclaimer slide that does that. You've got to have that. And then secondly, watch out for the Q&A. That is by far and away the most dangerous part of the talk, because obviously that's the part that you're not in control. It's not scripted, right? So I will share with you, I have a great technique for this. And Kathy knows it very well, too. I've shared this with her for other speakers as well. See, what I do is I just go over my allotted time and talk through the Q&A so nobody has time to ask any questions, and that way I can sleep better at night. So that's a great trick, and I would strongly encourage it for you. Okay, social networking, they talked about this. Any in-house lawyers here? Any in-house lawyers here? Okay, take a photo of that slide. I'll give you 2 seconds to do it. We won't talk about this. Basically, don't do it. It's the world's worst job, and I'll talk about that afterwards if you have time. Okay, no, really, it is. Being an in-house lawyer is a no-win situation. Trust me on this. Okay, last but not least, dealing with ethics in the real world. Know the rules, know them code. One of your, I gave you as one of your handouts a wonderful link to all the stuff on the New York State Bar Association page that deals with ethics. It's the only page you'll ever need. It's like a nice little directory. Get a retainer letter with every client, every new matter. Don't rely on form documents, even if it's one of mine. Build a support network. Get other attorneys that you can call and ask ethical questions from time to time. Don't try to go this alone. And then when in doubt, yield not to temptation. There's plenty of other business out there, even in these difficult times. Now, I know I'm the ethics guy, but I'm also your last speaker here. So I want to leave you. You've been sitting in these chairs now for 2 days, and I know you're anxious to get out here. But I want to leave you with two parting thoughts here. And these are some of the most powerful things that I have learned in 35 years of practicing naked. And I'm going to read this. Please read this along with me. Whenever I have had sleepless nights over my law practice, got myself into an ethical gray area, or took an unnecessary risk, it was without exception because I gave in to the temptation to do something nice for someone, or I felt sorry for someone. Being ethical is essential to success in any profession, but being nice to the wrong people can get you killed. The trick is to know the difference, and remember, no one expects lawyers to be nice. Cynical, but very true. And then, finally, my benediction to you all. This is my motto. I've already been arranged to have this on my tombstone when the time comes. Never let a lack of knowledge, experience, or talent get in the way of success, because Lord knows it has never stopped me. Thank you. You have bridged the gap. Go home.
That concludes this segment of the program. For further information on continuing legal education, recordings, seminars, and publications, please contact the New York State Bar Association, located in Albany, New York, and online at www.nysba.org.